Philip Adams, what's up, man?
I'm doing pretty well. How about you?
Man, I'm good. So it's been probably like 2 years.
Yeah.
I've had this show for like 2.5 years, and you were one of the first, probably in the first 10 episodes. I think you were on. You and my cousin actually, who Greg Walker, who's a police officer, and that was an interesting conversation. But we never since then. You and I we know each other, and we meet every week in this networking group, and I hear all these things. Like every week you talking about, certain scenarios of what you do, being an attorney and, in criminal and personal injury. And I typically think that stuff's boring and mundane because most people do, because the way that that's portrayed. But it's, number one, it's someone's livelihood. And then number two, it's just extremely interesting how you break everything down. So, man, I just want to jump in the nuts and bolts. I mean, I guess we talked a long time ago about where you came up, what you did. But, I mean, let's just go into your, straight into the profession aspect and kind of run through it and what you're doing now, and then we can talk about all the other stuff.
Okay. In terms of what I do now, like you alluded to earlier, I handle criminal law and personal injury law cases. For the criminal law cases, I do everything from, low-level stuff to high-level stuff. So traffic tickets all the way up to homicide cases. And for injury cases, everything from car accidents to slip and falls to 18-wheeler accidents, wrongful death cases, things like that. My practice is usually pretty evenly divided between criminal law and personal injury cases, but it can fluctuate at times depending on what cases are coming in. And, I stay very busy. I tend to work very long hours. It often means working on the weekends, but I do that because that's what it takes to get the results that I want.
Yeah. Well, I admire that about you, too, because I feel like that you go above and beyond. And I haven't been with your clients personally, but I just, from what I see on the outside looking, I feel like you go above and beyond, and you actually give a shit, right? So what's your past, I know you work for the state, I believe, didn't you work state? Yeah. So, let's go through that. What all did you do there, and then what made you kind of want to get into this?
So, while I was in law school at the LSU Law Center in Baton Rouge, I clerked with the East Baton Rouge Parish DA's office, and that office has over.
What does that mean when someone says clerk?
So, basically, I was doing grunt work. I would do legal research and writing. I would attend court with them. Help them bring their files to court. And
Is this in line with like what a paralegal would do, or similar?
Yeah, kind of like that, but just more of like a souped-up paralegal.
Because got you.
Your law students have more knowledge typically than paralegals when it comes to like being able to help do legal research and writing to help attorneys. And so I did that, and then did it for 2 years actually while I was in law school. But while doing that, I also got sworn in as a Rule 20 attorney and had a chance to handle actual criminal cases in court, but under the supervision of a prosecutor.
Right.
So before I even graduated from law school, I had already been in criminal court countless times.
And you were on the prosecution side.
Yeah.
And now you're on the other side.
Yeah.
How does that play out? Like why? Why did you not go the route of what you had started doing and had practice in, I guess?
Yeah. I mean, that's a really good question. So I think that what both sides do is extremely important. If you're going to have a system of justice, you've got to have a system in which both sides do their jobs. And so I knew that I always wanted to do defense work from probably the first semester of law school.
Oh, so you didn't know that, you didn't get into doing prosecution and say, okay, I don't like this, I'd rather be on the other side.
Right.
Okay, gotcha.
That was intentional on my part. I wanted to get some internal experience in the prosecutor's office before, going straight into defense work at the law school. And so I did that, had a chance to learn how the internal, prosecutorial decisions are made and so forth. Made friendships there, and then after I graduated and passed the bar exam, applied for a job with the defense firm in Baton Rouge, doing only criminal defense, and did that for several years there in Baton Rouge. So
nice. And then you moved up here, and we're in North Louisiana. We're talking about in Shreveport, Louisiana, and then you got with Elton Ritchie.
Yeah.
And then you were associate for him for how long?
For 1 year. It was the year before he planned on retiring, and he had told me that. But I met Elton. It's kind of funny because I met Elton before I got hired, right?
Yeah.
But so the hiring aspect we both met at a Louisiana Association of Criminal Defense Lawyers, CLE, for continuing legal education. And he had mentioned that he had a job open. He was thinking about retiring, needed an associate to help for a year. And we struck up conversation, and I decided to run with that because I wanted to make my way back to the Arklatex. Because I've got family in Natchitoches Parish and just wanted to be closer now. To where if I want to go visit and see, my mom and dad or some of my brothers, I can drive an hour and be there and not have to drive several hours like I did whenever I lived in Baton Rouge and was practicing down there. But Elton said, yeah, come on. And so I went and worked for him for a year. But I had actually met Elton while I was working in that firm before I started working for that firm in Baton Rouge.
Okay.
So when I was applying for different possible jobs while I was taking the bar exam, Elton had actually brought up the idea of me working for him because we'd established contact, but I turned him down and took a job with the firm in Baton Rouge. But I actually wish I had taken a job with him initially.
Yeah.
So, but it's kind of funny how sometimes things come back full circle.
Right.
So.
Well, so since then, you worked with him for a little while, and then you went out on your own immediately thereafter.
Yeah.
How long you been out on your own now?
Gosh, it's been I'm in my 8th year of legal practice. So I graduated in 2015. I was in Baton Rouge for about 2.5 years. So, I mean, you're looking at like probably over 5 years now. Yeah.
Well, I mean, what have you seen? Like, let's just jump into it. So, like, what have you seen that it just screams to people, like, or what screams to you to share with people? Like, there's always that lingo, like, if you get in a wreck, call an attorney. Yeah. But like, what's important? Like, because I feel like so many people don't understand what an attorney does. They just know I'm in trouble, or I may be in trouble, even though I didn't do anything. I need to pay this person because they know more about the law than I do.
Yeah.
But I'm more like, and we've had conversations outside of this, and that's why I want to do this. I'm more like to hear the side you're on, like the defense side, because there's so many people that are wrongfully accused and prosecuted that shouldn't be.
Yeah.
And like, so yeah, anyways, let's get into it.
So for me, I think the thing that screams out to me in legal practice is making sure that I do my job in a thorough manner. So I believe that you got to be almost hyper meticulous, because if you're not, something's going to be missed. And I've seen time and time again cases in which police officers failed to adequately investigate, cases in which defendants were not even interviewed but an arrest was still made. So police come into a case having one side of a case, not having heard from the side that's actually being accused of the crime itself, right? I've seen, car accident cases in which adjusters will get a police report but not bother to get body cam footage associated with that police report, dash cam footage, or written witness statements from the scene. Like, I'll give you an example. I had a car accident case recently in which the report listed the accident as being a minor accident, but then when I get witness statements and get pictures of what happened, I see a vehicle that's totaled and that's just completely crumpled up.
Yeah, but it's a minor accident.
But it was characterized by the officers being a minor accident.
Why do you think that is, though?
I think that
you think it's workload?
I think workload plays a role. I think laziness
depending on the city,
role.
too. Was this in locally?
This is Shreveport. Yeah. It's workload definitely plays a role. I think laziness plays a role for sometimes. Oversight does. But the thing is, if you're an officer and you sign your name to a police report, you're implying that you've read that report, you've reviewed it, and that what you put into that report is accurate and it's complete. And if you put into a report that the accident's minor, but then we've got photographs that show that a vehicle looks like somebody dropped a bomb on it, that calls them to question your credibility as an officer. Right. But
that's something that I feel like is an issue a lot. My wife's a police officer, and she's so OCD and over the top that she's always going back and correcting other officers' reports and making sure they're right and like talking to them or whatever. But like being on the side you're on of it, like especially the criminal side. Like, so what's some instances you've seen to where you're like, I'm doing everything I can, but this, like, there's a wall here, you know what I mean, or something like that. Like you know what I'm saying?
Yeah.
Yeah. Let me elaborate a little bit. That way you can get a little deeper. Okay, so say I did something, but I didn't really want to admit it, but maybe I didn't do it to the full extent that I was being charged.
Right.
But I still had some inclination to doing it, or so I was somewhat kind of involved, but it wasn't to that extreme. But I didn't feel comfortable telling you.
Yeah.
That, because then I think it would eradicate me, basically. You know what I mean?
Yeah. So what I do in a situation like that is, and it really starts from day one whenever a client comes to my office and we do an initial consultation. The way that I structured the initial consultation is I don't make it rush. It's not you've got 10 minutes and then you have to get out the door.
Right.
It's not. I once had an initial consult, and I kid you not, it lasted 7 hours.
Holy shit.
Yeah. I tell that to people, they're like, what?
What kind of case was it?
It was a self-defense case.
Okay.
So, involving an aggravated assault with the firearm charge.
That's the kind of stuff I want to talk about.
Yeah.
Yeah.
So, and I didn't even realize how much time was passing by until I went and looked at the clock. But I got so engrossed in questioning this guy and getting as much detail as I could from him, so I could give him adequate recommendation on how to proceed. That 7 hours had passed. And this was on a Friday.
That's crazy.
Whenever he came and consulted him and his wife in that case, but. So I sit the client down. I do a thorough, detailed initial consultation with no time limitations. It lasts as long as it needs to for me to get the information that I need for that consult. It doesn't mean I won't do follow-up consultation down the road to ask additional questions or get more information if new evidence comes to light or what have you. But at the initial stage, I'm going to make it thorough. But I do that, and I let the client know that, look, you've got to feel comfortable with me for you to hire me. And I have to feel comfortable with you. And one thing about that is that you have to be honest with me.
Yeah.
I have to know exactly what happened, not to judge you, because there's nothing you can tell me that will surprise me. Not when it comes to criminal law. And if you tell me exactly what happened, what you tell me is confidential, for one thing. But B, it enables me to give you reasonable advice.
Yeah.
So if you did something that was wrong, that violated the law, you need to tell me that, because you could have been overcharged.
Yeah.
Or maybe you were improperly charged. You were charged with one charge, you should have been charged with something else. If you've been overcharged, then we can put together a case, a defense, and then try to get the charge dropped down to a lower level to get you an outcome that is proportionate to what you actually did. And if the prosecutor won't do that and we're forced to try the case, then we can present that argument to a jury and let them make a judgment call on what they think is the best verdict in your case.
Well, that's something that's always scary too, right? Because you have to tell any client going into a trial that, hey, there is a chance you could be convicted here. Right. But if you take a deal early on, then you know exactly what you're walking into, right?
Right.
And I feel like that's something that scares the shit out of a lot of people. Even if they know that they may not have done that. Right. They still at least know what they're looking at, but walking in there blindly, it scares the shit out of a lot of people. So you have to instill that confidence in them, or at least know what the hell you're talking about to be confident on your side, too, to walk in there.
Right. Yeah, I do. When it comes, you do have to be realistic with clients, because you can be 100% factually innocent in a case, go before a jury, and still be convicted. And people say, well, how in the world is that possible? It's possible because you hear every day about people who spent 10, 15, 20, 30 years and more in prison, and their convictions get overturned because they were wrongfully convicted. In fact, the reason why we have appeals courts that exist is to review what happens at the trial court level to make sure that judges and juries are actually getting it right, because they don't always get it right. So we know it's possible because jurors are human beings. Sometimes they have to make close judgment calls. Yeah. They can be influenced or swayed by biased prosecutors. They don't have legal training, so they
could say you're guilty because they don't like the way you look.
That's possible,
or your skin color, or your or your gender.
That's very much possible,
because that's what's always crazy to me. And we talked about this a little bit. And I was like, we got to talk about this shit. That's what's so crazy to me is like, you get jury duty. First off, you don't want to be there. Yeah, like you got to go. It inflicts with your schedule. You usually don't have that big of a heads up, a couple weeks or whatever. Or month or something like that, whatever it is. You got to go. You show up, do it, and you don't want to be there, and then like you get in there and then you don't really have, like you said, you don't have any type of training. You know, if you're just a regular civilian that hasn't been, maybe a few people, maybe, you know, some type of scenario, but probably never even been, you know, in a courtroom, much less, you know, actually having an opinion. It's crazy to me that that's something that still works, or that's still used, excuse me.
Right. Yeah, it's a very interesting system, because there are other countries in which people don't have the right to a jury trial. They're tried by judges.
Yeah.
The judges make findings of fact, and they also make findings of law.
Well, do you think that, I don't mean to cut you off, but do you think so? Like, do you think that this is instilled because it gives some type of humanity to the judgment? You know, because the judge may just be ironclad about the facts here, but when you have a panel of jurors, that they may have a little bit more leniency in certain areas.
I think that's a really good point. I think that is definitely one of the factors that plays a role in why we still have retained the jury trial right here in the United States. Because when you've got, say you try before an ordinary jury of 12 of your peers, when you've got 12 people who all have to come together unanimously to find you guilty or not guilty, you've got 12 potential viewpoints in this group.
How does that process work? So they sit, I don't even know. I've never even been to jury duty. So how does that work?
So people will get called for jury service, and then groups of jurors will be, you know, ushered into the courtroom. The attorneys will both take chances asking questions of the jurors and kind of lightly introducing the jurors to what their cases will be about. They can't get into too much detail, though, not until trial starts. And once they've asked questions, they can then present challenges for cause. If a juror, for whatever reason, is believed by the attorney to not be able to be fair and impartial, an attorney can lodge a challenge for cause, or attorneys can actually use what are called peremptory challenges, too, in which they can challenge someone just because they don't like the way that attorney looked at them or their client. However, there are limitations on that. You can't use a peremptory challenge on the basis of race or gender. That's not allowed. But you can use a peremptory challenge for pretty much any other reason.
You could have that basis and just lie and say it's something else, right?
You could, exactly. Yeah, there are ways of detecting that. That's called a Batson challenge. And one of the telltale signs is that is if, say, a prosecutor or defense attorney, and it mainly applies to prosecutors, but it still applies to defense attorneys as well, is when one side is, say, striking all white jurors or all black jurors, and it starts to become apparent that this person's trying to get a jury that is composed of one race, or striking all female jurors because I don't think it would be good for my male client who's been charged with battering his wife, for instance, or vice versa. But you can't. I suppose there would be a way to do that if you were being dishonest and unethical as an attorney, and not draw red flags. And so, in some sense, the system relies upon attorneys as officers of the court making sure that they act in a professional and ethical manner. They don't always do that, and that's why we have attorney disciplinary boards. So
yeah, and I mean, you guys are pretty strict about that too. You make one good fuck up, and you're pretty much out of there.
Yeah,
and then you got to redo everything, right?
Yeah, because you
never can do it again, depending on the severance of it.
Yeah, you can completely lose the privilege, I think, of being able to practice law if you make a mistake that violates the rules of professional conduct, and the state Supreme Court believes that that's needed. So the state Supreme Court polices the privilege of practicing law in our state. So if you get hauled up before them, they have the ability to strip you of your license to practice law.
Damn.
So
after all that money and time, and you just make one mistake, and
it would usually have to be significant. Like an example would be like if an attorney embezzled client funds or went out and committed a major crime, then he or she could lose his or her right to practice law. If an attorney got a DWI, you might could have your law license suspended for some period of time, maybe 6 months to a year, depending on the discretion of the Office of Disciplinary Counsel and or the state Supreme Court if it made it that far. But usually the punishment is going to be proportionate to the violation that's committed by the attorney.
Gotcha. Well, what's your, like, where you at on, like, all these wrongful, like, people have been wrongfully accused for so many things, right?
Yeah.
Like, I know you're familiar with, we talked about this, like, the Innocent Project and, like, things that people have got into that, you know, just because, for instance, like, a scenario, someone is accused of rape, right? And this woman's, maybe she's in this alleyway, and then police get there and they immediately just see a gentleman walking down the, alleyway or whatever, and they assume that's the person, and then next thing you know, that person's in jail for 10 years. You know what I mean? And they didn't do anything, but they didn't have a chance to argue the case. One, because they were going up against, maybe they didn't have any money, for an attorney, or, just all those scenarios. Like, what is that? That has to, like, for me, like, I'm not in your shoes and I don't do what you do, but that has to be something that, like, makes you want to work even more towards, defending those people.
No, I completely agree. I mean, the thought of, like, having a client who were to be wrongfully convicted would be something that would just keep me up at night. Yeah. So, you can ask my wife, you can ask anybody who has been a client of mine and who knows how I work my cases. I'm so methodical and so meticulous that some people would say probably overly so. But I'd rather be known for that than be known for not being that way.
Right.
So, because I want to make sure that, like, justice is done in every sense of the word, not just whether or not the person's guilty or innocent, but, like, is this person been overcharged? Is this proportionate? And what have you. But, like, I mean, to take the example that you kind of alluded to about the idea of a woman being in an alleyway and being raped, I'll give you an example. There was I can't remember the name of the case, but there was a white woman who had been raped by an African-American male. And she had identified this defendant on the witness stand in court and said that was the man who had raped her. And then decades later, DNA evidence came out showing that he had not done that.
Really?
And so, but she had made an eyewitness misidentification because of the stress and heat of the moment, probably because it was a cross-racial identification in which she may not have been as familiar with, like facial appearance of somebody of a different ethnic background. There's a lot of psychological research that shows that, for instance, if you're white, you tend to be more easily able to identify a witness who also is white, who has a white face. But if it's someone of a different background, perhaps Hispanic or African American, you have a higher propensity to make a mistake in eyewitness identification. Because especially if you live in an area where you have less exposure to people of different ethnic backgrounds.
Right, got you.
So, but she had happened to make a mistake in that case, and it cost that man decades of his life.
So you don't think it was a malicious intent?
It wasn't malicious.
There,
it was inadvertent, and you've seen that happen in so many different ways in which I think witnesses are honestly mistaken, meaning that they genuinely believe what they tell law enforcement, but they can still be mistaken.
Yeah, it's always in the heat of the moment too, right?
Yeah.
Like, I mean, your adrenaline's through the roof, your heart rate's bumping. Whether it's someone got shot next to me, or I shot someone in self-defense, or this happened, this type of, thing happened to me, like, of course, like, I don't feel like that's the best time that's what's interesting, right? Like, that's all you have to go off of. And it's typically misconstrued because of all those variants.
Right. Or you've got police, too, if you've got a witness who's been traumatized, like in a rape case, for instance, and it happened at nighttime. So that's a red flag you have to look at. Because if it happened at nighttime, we have to be extra cautious about any eyewitness identification. Because at night, obviously, you typically cannot see as well. So you've got to look at all the different variables. Were there alleyway lights? Were there no lights? What was the race of the accuser versus the race of the defendant? But if police, for instance, grab one guy who they happen to see walking down the street, and they bring that one person to this woman who's been traumatized and she's psychologically vulnerable, she could think that subconsciously, the police already did their job and found the guy who did it to me. That must be him. Yeah, that's the one who did it. She could think that, not necessarily with malice, but because that's what's going on in her subconscious mind. Yeah. So human memory is very fallible, more so than people realize. If you look into like the neuroscience of human memory, it would shock you. But we could have an entirely
Let's talk about it. What's up? What's up, man?
I mean,
What's up?
It's like there's research that shows that we hallucinate a large part of waking reality. So,
in what aspect?
I'll give you an example. So, whenever you look at an object, for instance, your brain is going to take in a lot of detail in terms of what you're focused on, but your peripheral vision, your brain can be hallucinating many of those details based upon what it thinks should be there. So, which is kind of frightening, but our brains are just enormously complex. But these are things that we haven't really figured out until recently because of neuroscience. But in the past, all we had to go on was inconsistent statements. Is what this witness saying, does it comport with like what the physical evidence show, or does the physical evidence contradict what the witness is showing? And we still rely on those things, but we're getting a better understanding now of how people could make mistakes when it comes to like eyewitness identification, because of how the human brain actually works. So you have to look at every fact in the case to make sure that nothing's missed, because sometimes the witness could be malicious and sometimes the witness might not be malicious in terms of what they say. And most of the time the witnesses are being honest. Because most of the time people who are charged by police are in fact guilty. But you expect that if you have a system in which the police are doing their jobs.
Right. Well, so, but that happens a lot where they're not, right? Like, a lot of times it's just like show up, everybody's getting arrested. You know what I mean? Like, that happens. It happens.
Yeah, it does, unfortunately.
Like, or showing up and no one saw anything, but one person did. That one person may not be telling the truth, and then they make an arrest on that,
exactly.
based on that.
Or maybe the witness has a motive to lie against the defendant. Perhaps the person doesn't like the defendant. Or maybe the witness doesn't like that defendant, but likes the person who's the alleged victim, or they could have a relationship of some kind.
Oh, that happens a lot.
So it's very frequent.
I can only imagine how many people have been wrongfully convicted because that other person. It's just like anything else. They had enough people on their side, and they didn't have anyone. Even though they didn't do anything wrong, they can't argue it.
Yeah,
not based on facts, or as far as testimony and eyewitness and all that.
Yeah. I had a stabbing case years ago involving a guy who was leaving a bar, going out to his girlfriend's vehicle. They were in his girlfriend's vehicle. The doors were all closed. The vehicle was not locked, and these guys come out of the bar, and this is partially on video camera. Many of the incidents that happen. This is all public record.
Right.
And they are trying to yank open the door to get to the guy who then became my client later, who's in the front passenger seat. And they're also smacking the vehicle. You can see all this happening. And they managed to open the door and pull him out. This group of guys, big, strong guys, who looked like they were had been taking steroids. And he was just an ordinary sized guy. And they proceed to put him in a chokehold, and they start wailing on him. So, he's being punched in the head by the guy who's got him in a chokehold. Other guys are hitting him in the stomach. And his girlfriend even comes in and starts pounding on the guy who's got him in a chokehold to no effect.
Right.
He continues doing what he's doing. And then my client, who happened to have a knife on his person that he carried, for defense, as he's losing consciousness and being severely beaten by this group of males, he pulls out his knife and he lashes out and stabs the guy in front of him and the guy to the side. And there are multiple bartenders who are outside who are witnessing this, and his girlfriend witnesses this. Police get a call because there's been a stabbing, obviously. Yeah. They show up and they arrest my client.
And not those guys.
And not the guys.
Holy shit.
And here's what's horrible about it too, is that you got the surveillance footage that shows that they came to him. He did not go to them. It shows them pulling open the door to this is in Bossier Parish. Bossier Parish Sheriff's Office did this. It shows these guys yanking open this door, pounding on the vehicle, dragging him out, punching him, beating on him. It's hard to really make out the stabbing aspect, but you can kind of see what appears to look like stabbing. And the bartenders and my client's girlfriend and my client, who voluntarily chooses to talk to police whenever they come to the witness scene. In fact, he's the one who called 911. It happened after he had stabbed the guys. He got back in his vehicle and had his girlfriend lock the doors, and he picked up the phone and called 911. So he voluntarily talks to them, tells them what happened. The girlfriend corroborates. The bartenders corroborate. Surveillance footage corroborates the details that the footage could pick up.
Right.
And yet the police chose to arrest him.
Right.
So this is a case that, in my opinion, was an obvious self-defense case, because his life was threatened. He was losing consciousness. There was a disparity in numbers.
Yeah.
He wasn't facing.
How many guys was it?
It was I think it was 5 guys.
5 guys on one dude.
Yeah, so
5 large fellas on one small guy.
It was a disparity in numbers, and of course, if you're part of a group in a self-defense situation, if you're part of a group and you guys take collective action against somebody to hurt that person, you take on like the dimensions of being like one person.
Gotcha.
For purposes of like a group action.
Gotcha.
And so if there's a disparity in numbers like that, that tilts the scale significantly in a self-defense situation. Because even if they don't have lethal weapons on their persons, like a knife or a gun, their collective action could lead to you being in imminent danger of death to great bodily harm.
Right.
So, which in his case, he was in imminent danger of death to great bodily harm because he was experiencing great bodily harm. But in the moment, and when that happened, he was justified legally in pulling out a deadly weapon, a knife, to counter that disparity in numbers and that disparity in force that was happening. Because it was imminent, not just imminent, but was actually happening.
Yeah.
And there's a danger of death to great bodily harm in that situation. But the police, if they had known the law, or maybe they did know the law, I don't know. I don't think that they did. But if they had actually known self-defense law, they would have looked at these case facts and would have not made an arrest of him. In fact, they would have made an arrest of the guys who approached him and physically battered him. He was justified in stabbing them. They were not justified in attacking him and beating him to the point of almost near unconsciousness.
So what happened? What ended up happening with this?
I got the charges dismissed.
Okay, gotcha.
Yeah, he was charged with 2 counts of aggravated assault.
What were they charged with?
They were charged with nothing.
Nothing. So they got away with it.
Yeah.
And so
never charged
he
with
was
anything.
a victim, and he was facing charges. They never got charged with anything.
Nothing. Not even
Like, how does that
a
work,
misdemeanor, simple battery.
How does that
Nothing.
work? Like, so if the officials don't initially charge someone, once you argue it, can they go back and charge those people? You know what I mean? So, like, say you prove that they were the aggressor,
Yeah.
and they did it. Was there a system in place where they can say, okay, well, these people are now being charged with it, even though it wasn't even on the table initially because of based on officials reports and everything?
Yeah. Well, from a criminal law standpoint, there's nothing that you can do to force the law enforcement to do their job, which is scary. So here, in a situation like that, they can make a decision on whether or not they want to reassess their evaluation.
But that's completely up to them.
It's completely up to them.
So they don't have to.
They don't have to.
There's no lawful abiding like force or anything where say you have to do this.
They do not have to. In fact, the U.S. Supreme Court ruled in a case years ago. I can't remember the exact name of it, but it's actual case law that police don't have a responsibility to protect you, a legal responsibility to protect you. So, and basically what that means is that in this situation, they're not legally required to go back and do the right thing. Mm-hmm. They have the discretion to do so because, they're the employees of an elected official who would be the sheriff himself. And just like with the prosecutor's office, the DA himself, he's got assistant DAs who are under him, but the DA is an elected official. He has complete discretion in choosing which prosecutions he brings. So if you go out and rape somebody or murder somebody, it doesn't matter how much anger the public has. The DA of your parents could choose not to charge you if he wanted to. It doesn't matter if he has a case in which there's 100% rock-solid proof. He has so much discretion that he could choose to not charge you, and there's nothing that the victim could do about it.
It's only a certain level, right? That's at a state level?
Yeah, that's at a state level.
Prosecution level?
The same at the federal level, too. Prosecutors have a tremendous amount of power. A federal prosecutor could do the exact same thing if there are facts that implicate federal jurisdiction. He can choose not to prosecute
That's what's frustrating, right? Like, we have a system that is somewhat proven to work over, hundreds of years, right?
Yeah.
But then at the same time, nothing has changed. The only time that it changes is when there's a certain case where specifics are, stuff happens, and they're like, okay, well, we need to go back and base this decision now we're making on this case because we've seen this scenario before.
Yeah.
Like, what's scary is, like, how everything's still operating. And of course, I know you're in it and you're doing it, and that's what you know, and that's what you do. But it is scary for these certain situations, right? Like, do you think laws need to be adjusted, like, for those people? Like, because that's what worries me. So, like, in that scenario, if I'm that guy, I'm getting my ass whooped. I pull out a knife to protect myself against 4 or 5 gentlemen. Yeah. And they are the ones that come out there and initially started it. They're not getting charged. That's just one. That's just one example, but I mean, there's got to be multiple examples. Like, if someone was shooting at you, and you were in fear for your life, and then you shot back and you hit them, but then you're charged and they're not. Like, that happens all the fucking time. We hear about it.
It could easily happen. And that's why we have courts to try to address.
But then even still,
you might not have.
You can't go. You may not can go back. You can just try to get this person off, but then there's still those people out there that aren't getting charged for it.
Yeah. You, from a criminal law standpoint, you would have no recourse if the powers that be decide they didn't want to do anything about it. You could, however, bring a civil action. So, like for that example that I used that former client, if he wanted to, he could have brought personal injury lawsuits against the guys who had attacked him and beaten him to the point of unconsciousness. But that's not, to me, that doesn't bring the same level of satisfaction as knowing that people are held accountable criminally for their actions whenever they actually violate the law.
Yeah.
So you might be able to get some money out of them if they've got any assets, but that's not going to make you feel the same as you would as if they were punished for having come to you and attacked you and beat you senseless. So the only checks and balances you have in a situation like that would be at the ballot box. So you vote for a new DA or you vote for a new sheriff, which is kind of a very
fucked up. You know what I mean? To think about, like, okay, so the right person's in office now, so they're going to make something happen. Like, when we have this judicial system that's supposed to work and function and be, equal to everyone, or at least have, some type of, just like equality to it, I guess, or whatever.
Yeah, you got, and it's definitely an imperfect system. It's not infallible, that's for certain. And sometimes you have bad actors. I've had prosecutors who will push cases in which I've sat down with them, walked through all the evidence, and no reasonable person would disagree. Like it's solid evidence showing that the charges need to be dismissed. And the prosecutor would follow up with, so does he want to accept the plea offer? Would he plead to this felony, even if I don't give him any jail time?
Well, isn't that also because of numbers? They don't want those, isn't that something like to do with, on that side, the prosecution side, like they don't want to show that they didn't, convict X amount of people?
I think if you're an unethical prosecutor, then yeah, you may have that type of mindset. You're trying to get your conviction numbers up. But if you actually care about the law and you're a professional and you're following the rules of professional conduct, you should never ever push a case for which there's not sufficient evidence. Yeah. Never. You should be willing to listen to opposing counsel. If opposing counsel can convince you that the case should be dismissed. But you can't be myopic. You can't have blinders on. You have to be open-minded and be willing to listen.
Yeah.
So, but sometimes that will happen. I've had prosecutors do that before, and then, of course, my follow-up is, no, he's not going to plead anything because he's innocent. And he refuses to accept any plea offer. And we have to do further litigation, and then eventually wind up dismissing. That's super frustrating.
Because you knew from the jump.
Because from the jump,
you showed him everything.
I showed, but they still wanted to play games with the system in the hopes that maybe they could get something out of your client. But you had to work them hard enough to where eventually they realized that, okay, this is not worth the fight. I'm going to dismiss. Or they realized that, well, they're serious about going to trial. I don't want to go to trial and lose to this defense attorney, so I probably should dismiss. So.
Is there some like at the state level and of course the federal level too? Is there like, do you feel like there may be some sort of, based on who's, delegating that one area, they need to show a little bit of, you see what I'm getting at here? Like they need to show like they've been doing their job, you know what I mean? Even though they may not, those person on the other side may not deserve it, but they're, sitting here convicting these people left and right, even though,
we've got like for serious cases, you've got like the right to a grand jury. So grand juries, but
what's the difference between a grand jury and just a jury of your peers?
So a jury of your peers is constituted to decide guilt or innocence, right?
Okay.
In a trial. But a grand jury is something that's formed at the outset of a case.
Okay.
So if you get into a self-defense situation, as an example, and you shoot and kill somebody in self-defense, but the police feel that you didn't do it in self-defense and they arrest you, then you've got to go before. You got to have your case presented to a grand jury to decide whether or not an indictment will issue. So when an indictment comes from a grand jury, it's basically a formal accusation that the grand jury believes that there's probable cause to believe that you've committed the crime that you've been charged with. It's not the same thing as they believe that there's proof beyond a reasonable doubt of guilt. They just simply believe there's just probable cause. And of course, probable cause is a low level of proof. Beyond a reasonable doubt is significantly higher. But the thing about grand juries is that I think they need to be revised because with the grand jury system, the prosecutor calls the shots. Oh. The prosecutor gets to literally dictate every shred of evidence that comes before the grand jury or doesn't come before the grand jury. He does not have to present exculpatory evidence if he doesn't want to, and the defense attorney has no right to question any witnesses before the grand jury or speak before the grand jury.
Why is that, you think?
That's what the law says. There's a joke within the legal system that any prosecutor who's worth, his salt can indict a ham sandwich.
Yeah.
Because he gets to stack the cards,
then
right?
What's the point of having it? That's what's interesting, right? Like, what's the point of having that and those people in place whenever one side's already leveraged to win?
Yeah, the theory is that the grand jury might still serve as a check and balance and still come back with a no bill, no indictment.
Yeah, but if the prosecutor, it's their job to prosecute, and they're, providing all that evidence, and you can't object to it, or really, or argue anything or question any, like, that's just crazy to me.
I know you would think that the defense would be able to at least like preliminarily do some of that, but you don't have the right to do that. You do have the right to testify before a grand jury, but again, if you're a defendant, you can testify before the grand jury, but subject to the questioning from the prosecutor. Your defense attorney can't ask you questions in rebuttal or to rehabilitate you or follow up or show more details to show the full picture. The prosecutor gets to call the show again, even whenever you testify in front of a grand jury. So it's a one-sided affair, and in my opinion, it needs to be revised. I think it does provide some measure of checks and balances because grand juries do sometimes come back and don't indict, but they would probably fail to indict more often if the defense if there were a more equal playing field.
Yeah.
So, and if we had a more equal playing field too, you'd have fewer people who are actually innocent being drugged through a stressful, expensive system because you'd be catching it on the front end instead of catching it on the back end before or during trial. So I think that society would benefit by revising the system to make it more equitable. We'd benefit in terms of saving time and resources.
I would think so, right? I mean, you would think on both sides would benefit from it, right?
Yeah, absolutely.
Because you think of that, then they're having to go back and like right all the wrongs and like look like idiots or or whatever or like that this person wasn't done their or whatever they were
their due diligence.
Their due diligence. Excuse me, I can't think right now. But yeah, so yeah, man, what's the story? Like, what's the story you have, or something that you can talk about that's public record, that's kind of like the prime example of who you are, what you do, and what you can get done.
Okay, so I'll use a recent case as an example. So about 2 weeks ago, I had a client who I got his conviction overturned through a writ application to the Third Circuit Court of Appeals. He had been charged with resisting an officer for failing to provide his name. This is an incident that happened at the Natchitoches Parish Library, and he was denied the right to an attorney. He was a homeless guy, honorably discharged veteran, and he was indigent, so he was entitled to at least a public defender. And he to his credit, had done an admirable job of representing himself, even though he was denied his right to an attorney. But
why was he denied the right to an attorney?
Because the judge didn't follow the law.
Okay.
Yeah,
okay.
This is elementary criminal law. The judge should have known better, in my opinion. But he was wrongfully denied his right to an attorney, so he was forced to represent himself at the pretrial stage, and then at the trial stage also represent himself, which for him I imagine was a bit daunting. He gets convicted by the judge, of course, and the judge sentenced him to 30 days in jail and a $411 fine for just simply failing to provide his name to officers who had approached him. So for an officer to be able to legally demand that you provide your name and or your identification, the officer's got to have a legal seizure of your person. So the seizure can be a detention or it can be an arrest. For it to be a lawful detention, there's got to be reasonable, articulable suspicion that you have committed, are committing, or you're about to commit a crime. And for probable cause, there's got to be basically a fair probability that you've committed a crime.
Yeah, but that's subjective, right?
It's very subjective, right? So officers have to make that call. But, in my client's case, I argued that there was no lawful seizure. He had the officers had no legal grounds to demand that he provide his name. There was no criminal activity that was underfoot. They never found any evidence whatsoever of any type of crime, even after they put handcuffs on him for failing to provide his name. Even after they searched all of his belongings, no criminal activity whatsoever. There was never any allegation that he had made any threats to anybody at the library, nothing. And of course, under those facts, he winds up being convicted and doing almost a month in jail, which is unbelievable in my opinion. But it did happen. And then I brought 4 assignments of error to the Third Circuit and a 600-plus page writ application, and because I got hired after the case had happened, after the trial.
Okay, yeah. So how's that happen? So his homeless guy doesn't have any money, doesn't have anywhere to live.
Yeah.
Represents himself. Why is he denied a right to an attorney? First off.
Because the judge didn't follow the law.
So that's it.
Just
okay,
didn't follow the law.
Just chose to. You can't have an attorney.
Yeah.
So you got to represent yourself. So then how do you get brought in?
So some concerned citizens found out about his case, and they set up a GoFundMe account, and they raised money, and then they found me on the internet somehow. And they said they also had called my former boss in Baton Rouge, actually.
Nice.
And he had recommended me up here in Shreveport. And so they reached out to me, we established a relationship, and they hired me through the GoFundMe funds. So I come in, file post-trial motions, and then take a writ application to the Third Circuit, a supervisory writ application. And we wait probably over 7 months, and then as of 2 weeks ago, they rendered an opinion in which they vacated his conviction unanimously and vacated his sentence and ordered a retrial on the grounds that he had been denied his right to the assistance of the counsel. So, yeah, I mean, that to me, that case exemplifies why I do what I do, because even though it was a misdemeanor case, misdemeanor resisting an officer, and it just involved a failure to provide his name, people say that's a really trivial case. But it's not trivial
that's
because...
what I was going to bring up, because someone hears that and that's not a big a deal. But if they're doing that much at the front of something that simple, that's not that big of a deal, imagine what they're doing on a complex situation.
Exactly. And it's and this was something that, frankly, I think the judge and the prosecutor should have caught on the front end. The prosecutor had been prosecuting for several decades. He should have known that my client was entitled to an attorney and should have brought that to the attention of the judge. The judge should have known that as well, but nobody caught it, unfortunately. But, yeah, and I got involved and then got the conviction overturned. But even though it was for a small case of misdemeanor, I think the ramifications are serious, because the case kind of goes to the heart of the legal barriers that should be in place between law enforcement officers and civilians. You got to have evidence to be able to justify interfering with the liberty of a citizen, even if he's a homeless man, even if he's somebody who it's easy for people to just kind of subconsciously dismiss or overlook. You still have to care enough about preserving our system of justice to where you're willing to go all the way for somebody who's even homeless. And I mean, to me, that case kind of exemplifies why I do what I do. I've handled murder cases, rape cases, far more serious cases in terms of the potential consequences. But in terms of recent litigation, I've got a lot of satisfaction out of getting his conviction overturned unanimously, because it doesn't happen often, A, and then B, it means a lot to know that I'm holding the system accountable, even for somebody who's a homeless person. Yeah. So,
well, do you think it's our due diligence as a society to take it upon ourselves to, if we're in the area of something happening and we are an eyewitness? I mean, well, how do you feel about that? Because there's a lot of people that just don't want to, don't want to deal with it and won't give their statement or whatever, and basically there's a scenario, but they don't want to be tied up in it because they don't want to be connected to it somehow, even though they probably should because they were there. And then what if that person didn't do anything, did or didn't? If they did do something and they need to be held accountable, or they didn't and they need some sort of protection?
I think it comes down to the golden rule. We should treat others as we want to be treated. Assuming you're rational and you're sane. If you're crazy and you like being punched in the face, you probably don't want to treat other people the same way. Right. But assuming you're sane, you should strive to treat people the way that you'd want to be treated, and just put yourself in the shoes of somebody else. If you've been assaulted or you've been victimized by a criminal, how would you want somebody to treat you if they're a third-party witness. You'd want that person to speak up for you. Or if you're an innocent person and you've been wrongfully accused, wouldn't you want somebody who saw what actually happened to come forward and tell law enforcement that, look, this guy didn't actually do it. This person did it. He ran off down the street.
Yeah.
You missed him. You got the wrong guy. I was there. I saw what happened. Just put yourself in somebody else's shoes.
Well, I think people just dismiss it and move on with their lives and don't realize the severity of not speaking up, right?
Yeah.
Because that person could then be convicted for that. In that guy's case was a month, and that has nothing to do with anything, but they could be convicted for 30 years. We've seen these things.
You could, yeah.
You know?
You could have your life, completely devastated.
For nothing.
You could lose, like, if you could lose your wife, access to your children. You could lose custody of them if you got convicted wrongfully on a murder charge. You could lose a significant amount of financial assets if the decedent's family decided to sue you in civil court because they thought that you blew their brains out of their loved one. Maybe you didn't. There's so much on the line that I don't see how somebody could just be dismissive about not speaking up whenever they should.
Well, and so here's another side of it. So we look at the other side. So you have your side, and then you look at the other side of it where you're law enforcement, and especially this day and age of the past 4 or 5 years, what's been going on there.
Yeah.
You show up to something, and then immediately all eyes are on you. And so then you're on pins and needles to try to make the decision. I feel like they may have something to do with it too. Like, okay, well, I just need to get in and get out of here and get things done,
yeah.
and not exert myself anymore because then they may say that I did something, just waiting for me to say the wrong thing or make the wrong movement.
Yeah.
And not to mention there's so many bad apples out there. I talk about this with my wife all the time. She's like, there's so many instances where there's police brutality and racism and all that happens. But on the other side of it, like, there's a lot of good cops out there that are trying to do the right thing,
Yeah. No, I completely agree with you. I'm pro-police, and people say, what? Defense attorney saying that? Absolutely. I believe very strongly in law enforcement. And we as a society, we cannot blame law enforcement officers for failing to do their jobs if they're underpaid and or under-resourced.
Yeah.
If you want to have a system that works better, you've got to make sure these officers are paid adequately, that they enjoy their jobs, that their hours are not crazy, and that they're reasonable and manageable. That means you've got to hire more officers, and you hire more officers. If it means you keep the same number of officers you have, and perhaps you just discount the trivial stuff, like maybe you don't make pot arrests, and you focus more on the rapes and homicides. You've got to structure your system to where every officer is not in a situation in which he or she feels like he's got to cut corners to be able to get the job done. Because what winds up happening is the job doesn't get done.
Yeah.
You wind up getting the wrong person, and then the guilty man goes free. Or you have other issues that arise. So,
yeah, it's just something that, like, it's a constant battle, and I feel like we're in and out of it every few years.
Yeah.
It's like then it gets to one extreme, right? It gets to one extreme to where crime is so bad that, like, oh my God, we need to do something about crime, and then it gets policed, and then at some point that gets too extreme, and then we have the police brutality, and you have all these cases where these officers doing things they shouldn't be doing to potential suspects or whatever,
yeah.
people they're arresting, and it's just a back and forth game. I feel like we're always fighting it, right?
Yeah, it is, and it comes down to funding to a large extent. People want more transparency among officers, but if a police agency doesn't have the funds to go buy body cams, then what do you expect?
Well, this is one thing I want to talk about, like the regular average citizen who has an opinion and has a voting opinion does not understand what these people are doing.
Right.
They don't understand what these people are doing every single day. They don't understand that these people may go to a rape homicide, and the next thing you know, they're going to get a dog out of someone's yard.
Yeah.
They don't get it. Like, there's just so much. Like, not to say, I'm in the middle on everything because I just feel like justice should be served as it should,
Right.
But, like, people need to realize that these people are stuck in these scenarios day in and day out that's, everything's a shit show,
yeah.
And just trying to make the right decisions. And then there's some bad seeds that just thrive on that and love it.
Yeah.
But then there's some that are just trying to do the right thing,
I think, it's our good officers should be commended. We should hug them, shake their hands, thank them every day, increase their salaries, give them more than adequate funding. The bad apples should be punished. They should be held accountable. But people don't understand the stresses that officers have to endure every day. They don't. I mean, some people do, but I think the majority of citizens don't. They're quick to blame and criticize based on something they know nothing about. I mean, you got people who, if an officer gets arrested for police brutality, people will automatically make an assumption. It doesn't matter, not even just for an officer, any type of criminal case. People will often jump the gun, so to speak, and make assumptions that, that person must be guilty. They would never have been arrested.
Yeah.
So where went the presumption of innocence? How do you know that? What evidence have you looked at as a civilian? Have you looked at all the evidence of the case? No. In fact, you will never look at all the evidence until the case is over, if then. The only people who will see all the evidence will be the jury.
And that's what's scary, because those people are on the jury.
Yeah. Yeah, but no, I think people we need to inculcate within society like this principle of not making assumptions. Withhold judgment until you've heard everything.
Yeah.
A, and then B, try to empathize with people, whether it be, defendants who are facing charges, whether it be officers who are dealing with the daily stresses of law enforcement work. Try to put yourself in those people's shoes so that you're not quick to rush to judgment, and so that you can help them do a better job if possible as a civilian. Maybe if it means going to the ballot box and approving a tax increase to buy body cam footage for the officers, so be it. Or if it means raising their salary, so be it. Or if it means raising the salary of public defenders or hiring more public defenders, so be it. But don't complain about the system not working if you're not willing to be part of the solution.
Yeah, I mean that's the tell-all tale, right? I mean, everyone's going to bitch about it. No one's going to do anything about it, and then it just kind of works itself out. Unfortunately, sometimes too far one way or the other.
Yeah,
you know what I mean?
Yeah.
Well, so I know you're a statistics guy, but I don't know how much you know off the top of your head.
Yeah.
But let's just talk. Like, what do you think? Like, how? I haven't even looked at the numbers, but like the wrongfully accused percentages. Do you even know what that would be, or has been over the past X amount of years they measure these things?
I don't have like percentages off the top of my head, but I know there have been hundreds of people who have been exonerated through, say, DNA evidence.
Yeah. Like,
they've been clearly exonerated. There's no, the witness changed their mind. Do we know the witness changed their mind because they're telling the truth, because the witness felt sorry about what they said initially? I mean, it's like, this is unequivocal wrongful conviction. We've had hundreds of cases like that. It usually happens whenever there's DNA science involved.
Right.
So when you've got actual raw science. In terms of, so that's in a general sense. In terms of my practice, I think I probably get a disproportionate number of clients who are wrongfully accused, just because I've become known since I've been up here for thriving off cases like that.
Yeah.
So, because people know that if they come to me, I'm going to actually be meticulous in working the case. I'm not just going to sell the client out or go cozy up to the prosecutor and look for the easiest plea deal. I'm going to, if the client's innocent, I'm going to work the cases if the client is innocent from day one, start preparing for trial, even if trial never happens. So I don't know if I'm the best person to give you insight on personal numbers in terms of what I've seen in my practice area, but from my practice life, I mean, I've seen a significant number of people who have been wrongfully accused.
More than not?
I mean, I don't know if I'd say that. I'd probably say more so guilty than innocent. But the percentage, if I had to quantify it, I mean, it'd be pretty high. You're looking at probably a fifth of my clients. I mean, they're factually innocent, but those cases often don't get brought to the public's attention because you know what winds up happening? You do all the defense investigatory work. You're meticulous. You build a rock solid case. You present the information to the prosecutor, and the case gets dismissed.
Right.
So it never makes it to the limelight when there's a big public trial or anything like that. It's dealt with on the front end if you've done your job very thoroughly. The best way to win as a defense attorney is to win at the pretrial stage.
Yeah.
If you can win at the pretrial stage, it makes you a more competent attorney than if you can win at the trial stage. You should be able to do both, obviously, if you've got the facts. Because we can't pull bunnies out of hats, right? We have to deal with the facts as they are. But if you can get cases dismissed regularly at the pretrial stage instead of having to go to trial and fight tooth and nail for every every wrongfully accused person and then get a jury to find your client not guilty, you've saved your client money, you've saved your client stress and time. And to me, that requires more skill and more competency than just simply, walking into court and putting on a Shakespearean play, in which you call your witnesses and you ask your questions, and then the jury makes a decision. So,
yeah, no, I think it's interesting that you've represented just as many on one side as the other, and that you still continue to practice that way, right? Like, so, these people may be guilty, but you're just trying to get them, tried just, as far as what did you actually do, and how these processes are in place, and are you going to be convicted based on that, or are they overly convicting you? You know what I mean?
Yeah. It's and to follow up on that, people will often ask, well, if you have a significant number of your clients who are guilty, how can you represent people like that?
Yeah.
And that's a great question to ask, but I'm not condoning any activity that a client engages in unless it's lawful activity. Then I will condone it. I will 100% stand behind that client. If it's activity that's clearly criminal, my job in the system is not to judge. It's to make sure that the system has due process, and due process is basically fancy legal terminology for making sure that you've got justice.
Right.
So it means basically the same thing. If that means that you have to make sure that the other person's guilty, but they're not guilty of what they're charged with, you make sure that there's not overcharging going on. Or maybe they're guilty and they're proportionately charged. Then your job is to show the part of your client that maybe the prosecutor's not aware of. Maybe this is this guy's first offense, and he's got a past history in which, I don't know, he worked at animal shelters and volunteered in the community. He was a great guy, and he just happened to screw up one time. Your job is to bring that, show it to the prosecutor, to help the prosecutor have a more comprehensive picture. So it's no matter what you do, whether you represent somebody who's guilty or who's not guilty, you play an important role as a defense attorney, and the same will be true for a prosecutor. The prosecutor plays a very important role too. But
do you feel the same sense of urgency or excitement going into a not guilty case versus a guilty case?
I mean,
I know that's a fucked up question to ask, but I'm keep it real.
Yeah, if I'm being honest, I think that I feel more passionate about representing somebody who I strongly believe is not guilty,
right,
versus somebody who I strongly believe is guilty. But that doesn't mean that I'm going to in any way shortchange representation for the guy who I believe is guilty. But I think that from a human standpoint, it would only be natural for you, if you're a decent person, only be natural for you to feel more passionate about the client who you strongly believe is innocent.
Well, I ask this because there's a lot of criminal attorneys that would prefer a guilty client and just work, make the money and then work a plea deal and be out of there.
Yeah.
And not do near the paperwork. So, I mean, me asking you that is only, like, I'm keeping all this in mind when we talk about these things, because I've seen it. I've been on the other side. I had a past life. I was on the other side of this shit, so I understand.
Yeah, I think that is a good point, because it's representing guilty people is probably much easier than representing somebody who's actually
I would
innocent.
think so,
because you've got even if they don't admit it to you, it's usually it's easier to resolve that case. Not always. Sometimes people will be just insist on going to trial, which they have the right to do that. But they don't have the right to lie to a jury. But if they want to go to trial, they can go to trial. But if you have an innocent man or woman, the stakes are really high, because you have to be able to look yourself in the mirror at nighttime before you go to bed and know that as an attorney, you're doing everything in your power to protect this client, to get this client's story fully in front of the jury, in front of the prosecutor, in front of all the different actors in the system, the judge. You may not be able to control the outcome completely, because we're dealing with a lot of human discretion at every turn. The prosecutor, judge, jurors. There's no way for an honest attorney to tell a client, yeah, I think you have an 80% chance of walking away from this case, from trial. If you do that, you're being unethical, and you're full of crap, because you have no way of knowing that.
Yeah.
All you can say is, look, you could be convicted. I think you probably won't, but I can't quantify that for you. But there's also a possibility that you could be convicted, and you have to just let your client make a decision on whether or not the client wants to risk that possibility by going to trial. And that gets into, you wind up having somebody who's innocent. I've seen this happen more times than not, who winds up accepting a plea deal.
Exactly.
Because they're scared out of their minds of going to trial, being wrongfully convicted, and then doing decades in prison.
Yeah. That's what I was alluding to earlier, because I mean, we've seen it happen.
Yeah.
Right. There's so many cases where it's happened, where these, are being dismissed now after they've spent so many times and finding someone that actually gives a shit about them to come back in there and say, hey, my client did not do these things. You guys just, didn't do your fucking job.
Yeah.
You know what I mean?
Or
they didn't have anyone to represent them, and so then they, which happens a lot.
Yeah, maybe you might have had somebody who's just a warm body standing next to you in court, who didn't really adequately and thoroughly investigate the case or work the case or analyze the evidence. And he just, from day one, accepted the prosecutor's narrative and said, yeah, your client's guilty. Yeah, he probably is guilty. I'll go with what you're saying. I trust you. And then you want to have somebody who's wrongfully convicted. Yeah. It happens more than people realize, because the defense attorney doesn't do his job, doesn't adequately investigate. The jury could get evidence in front of them that looks, okay, there's evidence here that shows he's guilty. But if there's exculpatory evidence out there, that is evidence that shows innocence, and they never see it, the jury could wrongfully convict the man based on only what they saw, and then later you wind up having that evidence showing innocence come to light because somebody found out about it. So
so it just takes that right person.
Takes the right person.
If they're not, then who knows what's going to happen?
I mean, that's
what's scary, man.
It's
just scary.
Game
it's scary, like, to think about it. And I'm just putting my mind, like I'm trying to put myself in the shoes of a regular, everyday citizen, right? That just gets in a position, not necessarily someone who's involved in crazy activities all the fucking time and doing, drinking and driving, or constantly in issue, in the bar environment where they're getting into dispute. Yeah. I'm just thinking about the regular average day Joe that may present themselves, or they be presented in the situation to where something happens.
Yeah.
And they have to react. And, based on the atmosphere, the people that then show up after it, and then everything else, what's going to happen from there. It's scary to think about.
Yeah, it's very scary. I mean, even as a defense attorney, I can't imagine how I would feel if I were in a situation in which I got wrongfully accused. Can you imagine that would be a novel to write, right?
Yeah.
Defense attorney gets wrongfully accused. But I can't imagine, like, say you got in a self-defense situation, which the stakes are really high. You had to shoot and kill somebody in self-defense, but then you got arrested for murder. Can you imagine the level of stress you'd be experiencing, the level of anxiety and worry? And you're being told that, the prosecutor let you plead to negligent homicide, a lower charge, do 5 years in prison. But if you go to trial and you're convicted, you get a life without parole. What do you want to do?
Right, exactly. You're going to take that deal, right? Because, but then when you do that, you're never going to be able to have a firearm again. You're never going to get probably good gainful employment because what's on your record, and so on and so forth. You know what I mean?
Yeah, it's exactly. You deal with consequences like that. I mean, you deal with reputational loss. It's just. And not only that, but also you lose 5 years.
Yeah, that too.
You should do no time if you're legally innocent.
But I mean, if I'm in those shoes, I might. That's what's. You're like, shit. I get it. I get it. I'm like, I could go to prison for life, or I can just take this lesser charge and only serve 5 years.
Yeah.
At least you have a light at the end of the tunnel.
Exactly.
When you're faced with that scenario to where you're like, it may be dark the rest of my life. It's understandable, but at the same time, it's fucked up. It's like, damn, man.
Yeah. No, it is. It's. I mean, even as a defense attorney, I think that if I were in a situation like that, I would be not forced, but, coerced is probably a better word.
Right.
But into taking a deal like that. Even if I knew I were legally innocent, I don't know if I would risk.
Because then you're putting it in their hands.
Yeah, exactly.
And who knows? And then it's based on like you said, the elected official.
Yeah, plays a big role. I could be the greatest criminal defense attorney that walks into a Caddo Parish courthouse, and the jury just still not be there.
Yeah,
it happens. So it's knowing what I know about juries, and you're dealing with the human element. I don't know how I would react in a situation like that. I'd probably be more inclined towards having the light at the end of the tunnel, like he said.
What's your advice to someone like just moving forward? Like just regular life, like moving forward, like what should they do? What should they watch out for? What should they, where should their headspace be?
Don't do stupid things.
That's right, of course. But I'm saying, like, if you're in a self-defense situation, or say you're in, just a scenario to where you're nearby and something happens and you're involved,
Yeah. I think, self-defense is probably going to be one of the highest stakes. So to
I feel like
follow
right?
up on that, if you're dealing with the possibility of like killing somebody and facing a possible murder charge, that's about as high as it gets. Short of raping somebody, but for rape there is no excuse on that. So there's no such thing as excusable rape. So there is a such thing as justifiable homicide, though, if you act in self-defense.
Right.
So let's just roll with that. So if you're in a situation like that, don't ever go to the action. Let the action come to you if it's going to come to you. You don't want to be the guy who has a gun in his hand who goes to the action. Because how does that appear?
Well, everybody's got that uncle that says, "Oh, so and so comes. I'm gonna shoot their ass." You know what I mean, or whatever.
Yeah, you don't want to be the initial aggressor or even appear to be the initial aggressor, because the thing is, a jury is going to have to make inferences about what they think happened. They will never know exactly what happened. They'll only be able to infer what happened based on how the evidence appears, and that's scary too. So if it's just you out there and there's no third-party witness, and then police show up and you've got a gun and somebody's dead, that's scary. Because what if a jury doesn't believe your story? Maybe there's something there that looks like you were the initial aggressor.
Maybe you were on Facebook for the past 3 years posting Second Amendment rights 24/7. You know what I mean? Like, not saying there's nothing wrong with that, but I'm just saying, how would that look?
Yeah, it could cause a prosecutor to raise his or her eyebrow and say, "I'm just going to charge this guy and let a jury sort it out." He shouldn't do that, right? You have the right to.
Right.
You have Second Amendment rights, but you just don't know what's going to go on in the head of anybody looking at a file that comes across their desk. But best thing to do is let the action come to you in a situation like that, and just follow the law. If you don't know what the law is, educate yourself. So in a self-defense situation, you can use lethal force if you're in imminent danger of death or great bodily harm. It can't be the guy. If I walk up to you and slap you in the face, you cannot pull out a gun or a knife and kill me.
Yeah.
Because I use non-deadly force and you use deadly force. So what you just did was disproportionate to what I did.
Flip the table.
Or vice versa, yeah. And because it's disproportionate, a reasonable jury is going to construe that as not being reasonable. So you have to have a reasonable belief that you're in imminent danger of death or great bodily harm, and that the killing is necessary to save yourself from that danger. Yeah, that's what the law actually says.
Yeah, because a lot of people, I've heard this. A lot of people say, "Well, you can just say I was in fear for my life."
Yeah,
it don't work. It doesn't work that way.
That's not what the law
says. There's got to be some kind of proof.
There's got to be proof. Like it's every element. You look at a self-defense case. You got to have innocence. You can't be the initial aggressor. To use layman's terms, you got to have imminence. It's going to be about to happen right now. Can't be 5 years from now. Somebody may shoot me. It's got to be about right now. You got to have proportionality. So you can't be disproportionate force. And there's the avoidance principle. In Louisiana, we have a stand your ground law. So as long as you're lawfully in a place where you have a right to be, you have no requirement to retreat. You can stand and meet force with proportionate force.
Proportionate
force is a key term. People often screw up in that sense.
Yeah, that's what I would think.
Yeah,
here's a scenario. You tell me this when you say that. That's what I think of. Guy comes in to rob a store.
Yeah.
Threatens to stab the cashier. Cashier unloads a clip on him. And you could argue that, right?
Yeah, you had to know all the facts of that situation, because here's how I would look at that, just that hypothetical.
Yeah.
First thing I would look at would be the imminence element. Okay. I look at all the elements, but the imminence element would be the first thing that pop up in my head as a defense practitioner. One way to look at that is to look at what's called the AOJ triad, so ability, opportunity, and jeopardy. So the guy has the ability to use that knife and stab the cashier if he appears to be that way, right? If he's if he's not in a wheelchair and strapped down,
right?
If he can stand up and walk around, then he's got the ability to do it. Well, does he have the opportunity? That's the next question to ask yourself when you're evaluating whether
you're on this side of the counter.
Maybe there's a counter between you and him, and maybe that counter goes all the way up to eye level, and he has no way of reaching over and stabbing you, and you've got metal bars between you and him. The opportunity there is that part is gone. And if any part of that triad is gone, you can't meet the imminence requirement. And if you can't meet one element of the self-defense requirements, you lose on self-defense. You can go to jail. But the jeopardy element would be, well, is it about to happen right now? So I'd have to know more about that hypothetical to know what would apply in that situation. But you would fail on at least the opportunity element. But now say it's a counter that's as tall as this, and you're right there.
Yeah.
And you tell me you're going to stab me if I don't give you money. Well, my belief has to be reasonable if you tell me that, and you got your hands like this, and I can see your hands, and I don't see any knife on your person, the imminence element is not quite yet there.
Right.
It's arguably really close.
And if we're just, most security cameras aren't picking up audio.
Exactly.
You know, we're just video.
You just video.
So it's like, you could say that person threatened you, but
who's going to know?
Yeah.
Yeah.
I mean,
you're close to it now, but now if you start reaching out and you pull up a knife and I see a knife, well, then I've got concrete evidence, okay? Imminence is obviously being met. He's threatening to use deadly force against me. I can respond with proportionate force, that is deadly force, and then you unload on him, completely justified. Completely.
Really?
Yeah. But if a guy's 100 feet away from you and he says, hey, give me your money or I'll stab your ass.
Right.
He's there brandishing a knife.
Yeah.
He's got the ability. Again, opportunity is not met. That AOJ tried on imminence. So, and then you can look at all the other elements, but just the imminence element was the first thing that would pop up in my head because he's so far away. Like the imminence element is not quite there. It's not about to happen right now. But now if he starts running towards you,
then you're faced with,
that's where things get dicey. Okay, he's 100 feet away, he's 75 feet away, 50 feet away. Well, there's what's called a teller drill in which somebody can cross 21 feet of distance with a knife or any type of weapon. In general, a person can cross 21 feet on an ordinary surface in 1.5 seconds, which is about the time that it takes to draw a weapon and fire if you're a trained police officer. So
what if you're just an armed citizen? That's what's scary too, right?
Yeah.
Because if you're not trained well enough with that firearm, and not even that, you could be the best shooter in the world. I've seen a bunch of fat ass people on YouTube that shoot guns, but if your reaction time's not there, or whatever, like you've never been put in a fight or flight scenario. You can make all types of mistakes. Just because you can shoot a target all day long don't mean shit. If you're not in that scenario, who knows? 100 yards to 50 yards, you might get freaked the fuck out and start shooting right then. That's what's scary about all of it, right?
Yeah.
Is it's always comes down to a lack of training and a lack of awareness.
Yeah.
I feel like,
Exactly.
And that could go from anywhere from a training with a gun to awareness of the law to awareness of a scenario to where you feel threatened, all those things. And I don't feel like we're ever going to be broadly educated on that because we just seem to educate ourselves on this shit that's mundane. It's not actually what doesn't really apply to what, we're dealing with in a real life scenario every day.
Yeah. Something that could be potentially useful.
Yeah, exactly.
As in saving your life.
Exactly.
But yeah, you would think people would know more about that or at least try to learn more about it. But yeah, it's there's nothing like more horrible, I think, than having a client who's honestly mistaken. But I acted in self-defense, and they genuinely believe that. But you have to tell that client, under the law, you did not.
Right.
Under the law, you're legally guilty. And that's hard because there's some people who do act in self-defense in their minds, not with any malice or ill intent, but because they thought they were justified in acting in a certain way. To give you an example, say, cashier example. You brought up a great example. That guy. Okay, say you're slow on the draw. You're very hesitant about shooting this guy. He lunges over the counter, tries to stab you, misses while you're pulling out the gun. He sees you have a gun. He freaks out, and he instantly starts to run away. You've now entered a situation in which he's retreating from you. Can you then walk out? Can you then follow him behind the door really fast and then start doom, shooting at him while he's running away and his back is turned? You cannot, because here's why.
You can, but you're not going to be able to claim self-defense, right?
You can, and you would be charged with murder.
Yeah,
so
that's fucking crazy.
Because you would not have a reasonable belief that you were in imminent danger of death or receiving great bodily harm, that the killing would be necessary to save yourself from that danger. Imminence is gone. There's no danger of you dying when he's running away from you. You would be charged with murder. Even though he's the one who precipitated the whole situation, if you shot and killed that guy in that scenario, you could be charged with murder and do life without parole on something like that. But if you're not aware of that, you could be honestly mistaken in thinking that I thought I had the right to do that. If he tried to kill me, I can neutralize him.
Well, okay, so yeah, because you at that point you have more force than he does too, right? So like that has something to do with it, or it doesn't have anything to do with it.
Well,
so like say he tries. I have a gun. I decide not to shoot him. He tries to stab me, misses, but then I come around the counter as he's walking away and we'll try to whoop his ass. Like, what's the scenario then?
It depends on what starts
because
happening.
Then the ratios change, right?
The dynamics change. Yeah,
right. So I've at this point I had more force than he did, but now I don't because he has a knife and
you're just using your fist,
right.
maybe. Yeah. Well, if he
or I just know jujitsu and I just submit him and break his arm or so whatever like.
Yeah, it's if he starts using turns around and then tries to re-engage with you, then use that knife again, then the ante is up and you can engage in lethal force again at that point.
Right.
So you'd almost have to break that case down into two separate cases. Like the first set of case facts, even though they happen within a relatively short period of time.
It's two different, yeah.
It's really two separate cases, but yeah, you'd be justified in using lethal force if he upped the ante. But even if he didn't have a knife, he could use lethal force with just his bare hands, and you could too. That's why you have to be careful about the amount of force you use in a situation like that. For instance, if you and I get into a fist fight, and we're on the sidewalk somewhere, maybe outside of a bar, we're both drunk, what have you, and I'm the one who comes up to you first, I'm the initial aggressor, and I punch you in the face, you're justified in hitting me back to defend yourself. But then say you start going beyond that. You're just enraged. You got alcohol in your system. You're like, I don't know why this dude would do this to me. I'm about to teach him a lesson. You jump on top of him and you start pounding my head into the pavement. So you literally are picking me up and doing that, right? Or you punch me in the face and my skull keeps hitting the back of that pavement. That could cause brain damage, a.k.a. great bodily harm, or it could possibly cause death, depending on how much force you're using and the frequency of the poundings. At that point, you could be entering a situation in which you're using vastly disproportionate force against an initial threat. And if you were to kill me, you could be charged with murder. So people have to, especially in a self-defense context, to be very careful about the amount of force they use.
Well, this all brings to light this. If you're going to use any force, you better be trained on that force.
Exactly.
Because if not, you could go overboard, right? Like if you're just that regular guy who just, I saw red, and then there it is.
Yeah.
Then you don't have an argument.
You're in trouble. Yeah. It's got to be proportionate and always necessary. Every single blow, every single type of self-defense action has got to meet all the elements of self-defense. So.
Well.
Yeah, it's
frightening. It's frightening. Not so much to me. I don't think about putting myself in those scenarios. But just, I feel like I'm aware enough to try to avoid those scenarios. If I am in those scenarios, try to make the right decisions. But there's a lot of people out there that just may not be educated, or never been in that type of scenario. And then it's fight or flight. It's just one of those things that takes over, and then it may be to your advantage or your disadvantage.
Yeah, exactly. We could win the battle but lose the war.
Exactly.
You could win the fight but then go to prison for the rest of your life.
Exactly.
Which is not, to me, would not be worth it.
No, hell no.
But
well, look, man, we've talked almost damn near an hour and a half. I think we got a good chunk of stuff out. We'll have to talk some more next time. But are there before we wrap this thing up? Is there anything you want to talk about, or anything we didn't cover, or any points you may want to get across that we didn't say?
I would like to thank you for having me on.
Oh yeah, man,
and letting me be a part of your podcast.
Yeah, I appreciate your time,
You didn't have
man.
to do that, but I appreciate that.
Oh hell yeah, dude! Always a good time chatting with you, man. Your wealth of knowledge, especially in your industry, and I'm always excited to hear everything you have to say, because you break it down, not just, it's never one-sided. You always present the facts, right?
Yeah.
And I think that's important. I think that's important in what you do in your career. I think that's extremely important. And so I admire you for that, man. So
I appreciate it.
All right, man. Thanks.